This is the sixth
I know.
time.
Yep.
Loaded up, beginning to end with treatment. Sixth time.
Yep.
He does what he wants to do. He doesn't give a shit about what he...
4 years, 6 violations, and a judge who finally said enough. But here is what nobody is talking about. The moment this man looked a judge in the eye, admitted everything, and still believed he was walking out of that courtroom free. That is the moment this story becomes something else entirely, not just a drug case, not just another violation hearing, something that exposes exactly how addiction, manipulation, and the limits of judicial patience collide inside a single American courtroom. Stay with this, because the ending is not what you expect. Doug Push had been given every chance the system legally allows. In May of 2022, a judge sentenced him to 4 years of community control, probation's stricter cousin, where every movement, every doctor visit, every urine sample is monitored and reported. It is not prison, but it is not freedom either. The state is essentially saying we believe you can rehabilitate, but we are watching every step you take. Doug walked out of that sentencing with treatment programs, a probation officer, and what should have been a clear path forward.
This is 21-1198. Doug Push on, violation of community control. First violation, submitted urine samples May 11th that registered 87 and 81 degrees and were considered invalid. You understand that charge?
I do, sir.
May 12th, failed to report as directed at probation. Understand that charge?
I do, sir.
Third, June 4th, submitted a urine sample positive for meth. You understand that charge?
I do, sir.
Mr. Reardon?
Your Honor, I've discussed these matters with my client, and we understand we're not here for the final hearing, but regardless, he is prepared to enter a plea of guilty to the charges and ask that the court proceed with sentence.
Is that what you want to do?
Yes, sir.
What's your plea to those allegations?
Guilty.
I'll accept your guilty plea and find you guilty.
6 weeks later, he was back in violation.
May 25th of 22, sentence of 4 years of community control with various forms of treatment. June 29th of 22, first violation, continued community control, more treatment. February 23rd of 23, sentenced on the next violation, continued community control, continued treatment. July 20th of 23, another violation, sentenced, continued community control, more treatment. May 27th of 25, another violation, continued community control. March 24 of 26, pled guilty to a community control violation, a week later sentenced, continued, extended for a year, more treatment. And then about 6 weeks later, May 11th, the violations start again.
The judge continued community control, added more treatment, gave him another chance. June 2020, 20 February 2023, by May 2025, March 2026. Each time Doug Push stood before the bench. Each time the system extended its hand. Each time something broke down within weeks. 5 violations across 4 years. And at every single hearing, the framework was the same. More treatment, more supervision, more time. The kind of patience most employers would never offer. The kind of grace most people in that situation never receive. But Doug was not just failing, he was actively deceiving. On May 11th, Doug submitted urine samples that registered at 87 and 81 degrees Fahrenheit. Human urine exits the body at approximately 98 degrees. Those numbers were not a fluke. That was substituted urine, fake cold, and caught. The very next day, May 12th, he failed to report to his probation officer as required. 3 weeks later, a urine sample came back positive for methamphetamine. 3 separate violations inside of 30 days.
First violation, submitted urine samples May 11th that registered 87 and 81 degrees and were considered invalid. You understand that charge?
I do, sir.
May 12th, failed to report as directed at probation. Understand that charge?
I do, sir.
Third, June 4th, submitted a urine sample positive for meth. You understand that?
And here is where the story takes a turn that should make anyone who has ever worked for someone who plays by different rules feel something deeply personal. Doug's probation officer had been calling him for weeks, calling and calling and calling. Doug later claimed he simply had not received the voicemails. The judge's response was 4 words, "That is complete nonsense," because everybody in that room knew the truth, and everybody in that room knew that Doug knew it too.
She'd been chasing you for a month, and you've been avoiding her.
I turned myself in, sir.
She'd call you and call you and call you and call you, and you ignore it. And then you claim a week later you just got her voicemails, which is complete bullshit. Everybody knows that. Okay. So you've been doing everything you can because you've been using the whole time.
Yes, sir.
Right?
Yes, sir.
When asked directly why he stopped attending his intensive outpatient program at Signature Health, Doug said he loved it, said it was really helping him, said he was learning about decision points and breaking cycles. He spoke about the classes with genuine warmth, and then the probation officer opened her file. Doug had last attended on May 6th. He called on May 22nd, promised he would return the following week, and was never seen again. He had been discharged from the program entirely. Not suspended, discharged. The program he claimed to love had formally closed the door on him.
So I wasn't dodging her, I wasn't using the whole time because Signature Health goes down to the decimal.
Tell me about this IOP at Signature Health.
I love it. It's really helping me. And I also love the one that Mr. Barry has been doing on Mondays with me. I have 3 more to go with him. It was a great class. I'm learning, what was it called? Decision points.
All right. So what does Signature show with regard to an IOP?
So Doug last attended on May 6th. He called on May 22nd, said he'd be back the following week, and he has never showed. He's been discharged from their services.
That's not what they told me.
Well, that's what they sent me this week.
Oh, I talked to him last week.
What did they tell you?
They told me that I come back to IOP, that I'm still in
So the last time you were there was May 6th.
I know, I talked to them last week before I turned myself in.
Why was the last time you were there May 6th?
Because that's when I had my, I went in, then the following week I had the thing on my chest. And I didn't go back because I had a warrant for my arrest and I didn't know if I was going to get called on there and get picked up there and go to jail while I was
That is the
sitting
pattern interrupt. Not that Doug failed, but that Doug described his own failure as success in open court under oath with the documentation sitting 10 feet away. This is the moment where addiction intersects with something courts are forced to weigh very carefully. Under community control law, a probation officer holds enormous supervisory authority. Conditions can include restrictions on which medical providers a defendant can see, requirements for prior approval before appointments, and mandatory disclosure of all health records through signed releases. Doug had seen a gastroenterologist without prior authorization. He claimed a skin infection had prevented him from reporting. His probation officer looked into it. The infection turned out to be an inflamed hair follicle. Not contagious, not life-threatening, not the emergency Doug had described, and the signed medical releases that would have confirmed any of his other claims. He said they were on his desk, at his shop. The documentation existed, he assured the court, just not here, not today, not when it mattered.
14, so that is 2 days after he went to the doctor without my permission because he was supposed to receive permission from myself to any doctor other than Signature Health, and it had to be life-threatening to see the doctor. He did send me the paperwork for this contagious rash, which I then referred to a dermatologist, and it was an inflamed hair follicle, not a contagious rash. I have no other documentation from any of these medical.
Why doesn't she have this documentation?
I don't know. I have the documentation. I would have brought it in.
Now here is a question worth sitting with. At what point does a system that was designed to rehabilitate become a system that is being used as a shield?
Why are you bringing in this fake urine in May?
Excuse me?
Why were you bringing in this fake urine in May, the first violation here?
May of what, last year?
May 11th.
Last year.
Oh,
The one that had the wrong temperature on it.
oh. Because I used.
Okay.
Because Doug understood the framework. He knew that each violation would likely result in more treatment, more time, more chances. His attorney even argued it in open court, Addicts rarely recover on the first or second attempt. That is true. Research supports it. But the judge had something to say about that too, and it is worth hearing clearly. He looked across that courtroom and said Doug needs to get Doug better.
So you started using after May 6th then?
Yes, sir.
Why?
I let my anger get the best of me.
What were you angry at? You were in this IOP, everything was going great. What were you angry at?
You want the truth? Me and my father. Me and my father got into an argument because the way he was talking to my mother.
What?
Me and my father got into an argument because of the way he was talking to my mother.
Okay.
So, me and him got into it, and I left angry, and I did something stupid. Because I did not like the way that he was mentally abusing my mother.
So then
we resolved this issue, me and him.
the logical thing to do is to go use some meth.
No, it's not.
And then to continue to use it. And to then avoid her at all costs. Seems like a good plan. Seems like you've learned a lot over 4 years of probation. See, with you, it's one excuse after another.
I understand
That's what it's
that.
been for 4 years.
I cannot get Doug better. She cannot get Doug better. Doug does not want to get better. That sentence landed like a verdict before the verdict. The attorney pressed on. Doug had a job. He supported his family. His relatives were sitting in the gallery that very day, and the judge acknowledged every single point, and then dismantled each one. Having a job is not a high bar. Having family in the courtroom is not evidence of changed behavior when the family has been in that same courtroom 5 times before and nothing has changed.
Mr. Reardon?
Your Honor, I guess what I would say is this. Obviously, there's no compelling argument regarding the number of violations. They are what they are. He is able to work, has a job.
He's always been able to work.
Yep.
Over 4 years of probation, he's always been able to work.
Well, that's a positive that he is able to work. He also has...
That's not setting a lofty bar.
I understand. He has family that he supports and is responsible for. They're here today
and for 4
supporting...
years, he's had family that he's been responsible for.
Yep, I know. And they're here today supporting him.
So
and
nothing has changed in 4 years.
there's a lot of things are the same. I guess what I would say is this, with addicts and substance abuse and addiction, there aren't many out there that get it the first, second, or even third time. Oftentimes they have to be...
This is the 6th
I know.
time.
Yep.
Load it up, beginning to end with treatment. 6th time.
Yep.
He does what he wants to do. He doesn't give a shit about what he should do. He just does whatever he wants to do because he wants to do it.
The real climax came when the judge read the full timeline aloud. Treatment provider after treatment provider. Brian Freeman Hyann, Concord Mental Health, Signature Health. Again and again the resources had been assembled, funded, and offered. And again the pattern repeated. At a certain point, the judge said, continuing community control stops being rehabilitation and starts being something else. It starts being a cycle that the defendant controls,
Or
not the court.
productive.
Wait a minute. Now wait a minute, Mr. Reardon. Okay? At the very beginning it was with Halcyon. Halcyon, isn't that Brian Freeman?
Yes, it is.
Brian, very good. One of the best.
Yes.
In a mental health evaluation.
Still talk to him.
He's a good guy.
Yes, he is.
And then when you come in, continue with Brian Freeman. And then the third time, continue with Brian Freeman. Then the next time, Lake or Concord, Lake House or Concord.
Concord.
Mental health again at Signature. So now, Halcyon, Concord, Signature, again, Signature. Okay. He's had treatment. He's had everything he can do.
Yep, that's true. But again, sometimes it takes more than once, more than twice, more than 5 times.
So we should just keep doing it Doug's way. That it
Well, I
hasn't
don't know if
worked in
that's
4
Doug's
years.
way. I would say that's a way to continue to try to get Doug better.
Okay, Doug needs to get Doug better. I can't get Doug better. She can't get Doug better. Doug don't want to get better. Doug don't put forth the effort to get better. Because Doug likes to do what Doug wants.
18 months in prison, that was the
What
sentence.
Doug wants to do, because every time he comes in here, it's the same thing. He's an addict. He's got a good job, he needs to get back to work. He needs treatment. So every time he comes in here, I put him back to work, get him treatment, and then he comes back here again. Anything else anybody wants to say?
Nothing further from us, Your Honor.
All right, I've gone back and reviewed the pre-sentence report and the drug and alcohol evaluation, the entire record in this case. So it's clear you are not amenable to community control anymore after 6 violations.
All counts running concurrent with credit for 172 days already served.
And the costs are assessed. When you get out, you might be on post-release control for up to 2 years. Under the parole authority with conditions, if you violate, the parole authority can return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation is a new felony, you could get an additional consecutive sentence for the violation, the maximum of which will be the greater of 12 months or the time left under post-release control. Anything more, Mr. Reardon?
Nothing.
When Doug walked out of that courtroom, it was not in the direction he had planned.
So on count 1, a felony 4, I'm going to sentence you to 18 months in prison. Count 3, 12 months. Count 5, 12 months. Count 7, 12 months. And count 8, 12 months, with credit for 172 days. The counts will run concurrent to one another, and the costs are assessed. When you get out, you might be on post-release control for up to 2 years. Under the parole authority with conditions, if you violate, the parole authority can return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If the violation is a new felony, you could get an additional consecutive sentence for the violation, the maximum of which will be the greater of 12 months or the time left under post-release control. Anything more, Mr. Reardon?
Nothing
Was
further,
it
Your
justice? Partially. The system gave Doug Push more chances than most people ever receive, and he burned every single one of them. But the underlying question, whether prison actually addresses addiction better than community-based treatment, remains genuinely unresolved. The judge was not wrong to finally draw the line. The frustration is that drawing the line solves today's problem and almost certainly does not solve dose. When the powerful protect themselves and the system finally acts, it is often the person at the very bottom who absorbs the full consequence. The lesson here is not that patience is weakness. It is that accountability without buy-in from the person being held accountable is a loop, not a path forward. Comment below with a courtroom case or legal moment you want us to cover next. Subscribe and share this video, because an informed public is the only real check on a system that often operates when nobody is watching.